All right, welcome to the Resolution Room. This afternoon I'm joined with three other guests, and this is a follow-on from the last topic on PTSD, and we're going to drill down in some practical ramifications. Let me do some intros if I can first. This is in collaboration with MLCOA, so thanks for coming on board. Vanessa, Daniel, tell us about your role.
Thank you, Damien. Thank you for having us. I'm the National Customer and Legal Manager at MLCOA, and I work with the concierge team, manage the concierge team, and we just simplify the medico-legal process so people can reach out to us and we can assist them with any of their needs.
And you brought one of your lead medico-legal experts with us
We're
today.
very lucky.
Dr Lovell, you're a forensic psychiatrist. You were in private practice, but you've really spent a lot of your time in the forensic, in the legal adjacent space for many years. You're also a co-author of PERS.
That's correct. I've been in forensic practice since 96,
Right.
and I think we wrote PERS in 2000.
Well, we've got you to blame for the lack of contention now in the GD assessment.
Oh, dear. It's always my fault.
And finally, last but not least, Charlotte Campbell. Charlotte, welcome to the podcast.
Pleasure to be here.
Charlotte's a barrister, admitted, called to the bar in 2021. Before that, you were a solicitor for many years.
Yes, I was.
Charlotte also tells me to tell the audience that she's a Brisbane Lions supporter, and she has a thing for Rusty. She likes the what do they call them? The
South Sydney Rabbitohs.
Rabbitohs. There you go.
You're defaming me with a rusty comment, but I'll let it slide.
Let it slide. All right. So that's by way of intro. I've certainly worked with Charlotte as a mediator on both sides of the fence, actually. She has both a plaintiff and a defendant practice as a young gun at the bar. But let's go back in time to what we covered off last time. PTSD, there's a rise more broadly of secondary psychological conditions and primary psychological conditions. It's causing strain generally in various insurance schemes. It's obviously there's a destigmatisation, which is quite welcome, and an increased mental health literacy, which is also a positive thing. But of course, it comes with its challenges. Last time we spoke about PTSD, we spoke about the qualifying criteria, the category A stressor, the various symptoms that you need, the lack of objective daily functioning. And that was a great conversation. I'll go back to that conversation for all interested, because we covered off in some detail about what it is and what it isn't. And I guess the often dispute in clinical practice or forensic practice comes down to that versus an adjustment disorder. We looked at treatment, prognosis, and we kind of touched on the mystery of resilience and causation, but we're going to go back to that. All right. So have I set the scene? Did I miss anything last time, Vanessa? You were there.
I don't think so.
Good.
You did a good job. Thank
Excellent.
you, Damien.
No problem. All right. Let's talk now about how you navigate someone with PTSD from a practical perspective, say Charlotte's role as a lawyer, particularly when you have avoidance. And I guess that begs the bigger question of what is a trauma-informed process and how do we make allowance? I'll maybe ask you to comment first on that before I pass over to Charlotte, Doctor.
Well, I guess by the time it gets to Charlotte, the process has been rather protracted. Hopefully, many of them don't get to you because they will improve with natural resilience and psychiatric first aid. But unfortunately, a lot of people don't have early interventions. There are events that have happened previously, particularly in employment, if they happen to be the third person who's lost a finger or a hand in the workplace and work haven't acted, and they decide that a legal remedy is a path that they're going to follow. When you're dealing with somebody with PTSD, I guess the first thing you as a lawyer want to know is what happened,
Yes, certainly.
their experience of what they've been through. That is often very difficult because people, when they've had awful traumatic experiences, don't want to talk about it. They try not to think about it. One of the reasons that they get the dreams is because they don't think about it and they haven't processed it, and it comes through a dream, which is the royal road to the unconscious. When they're making their statement, you need to be very empathic. You need to let them set the pace. You need to let them perhaps use a narrative that they've written before, and you shouldn't interrogate them. That increases anxiety. It sometimes makes them feel that their symptoms are being doubted when you ask a whole heap of questions.
So that can mean cross-examining them, interrogating them,
Yeah.
asking them repeated questions.
I mean, you need to prepare them for what is re-traumatisation, essentially. The legal process is at least as traumatic as the original stressor, because, I mean, they've got to tell their story 15 times. Not everybody that they see is particularly pleasant to them, particularly some of the defendant psychiatrists. And there's a real sense of dread and anxiety and a sense of relief when the interview's finished. I mean, if I've got a good history of trauma from before, I won't take a history of the trauma. I'll say, how are you affected by what happened? And people are often grateful for that because we're interested in maximal medical improvement and what their level of functioning is rather than what actually happened. I mean, often there's no doubt that what happened and it was absolutely awful. And there's not a lot to be gained by interrogating them more.
I think a lot of lawyers find it really difficult when someone comes through the door for the first time and they have to get history and story out of them at least once, particularly when it's on the more severe end of the scale. I think you spoke earlier about some avoidant behaviours and them not wanting to rehash the story, which is completely understandable if you have PTSD. But what's your advice or your tips about in that first meeting or two, what's the best way to try and make a client feel comfortable or to prompt them to try and start telling their story?
Well, look, I never start by asking them about the event. I will also maybe read out to them something that someone else has written if I have to clarify that. It's about rapport and it's about trust. People who are in the legal system have a lot of mistrust and they think the insurer is out to get them or they're being followed. Ask them a little bit about their life, find out what they do, how they're getting on, why they're making the claim, and gradually they will relax. Often people bring some notes. I will let them use those notes because it's a good aid memoir, because if people are highly anxious, they can't organise their thoughts and tell their story in a way that does them justice. It's about being kind, empathic, not going straight for the jugular and not cross-examining them in that initial interview.
One approach I use, because oftentimes I'm seeing a client for the first time face-to-face at a settlement conference. So the claim may have been going on for months or sometimes years. So one approach I try and use is if liability, so fault is an issue, and quantum, so how much a claim is worth, I often, with a client with PTSD or a psychiatric injury, I'll go through the quantum side of things first to give them some time to get used to me, build some rapport, though it's difficult in a short amount of time. I go through that. I'll try and ask questions based on the material I've seen, like if they have a dog or if they're into a certain sports team, just to build some relationship. And then I always then go back at the end and try and talk about if I need to ask any questions about what happened or the event. But one other thing I like to do right at the start is if I don't have to ask them about the event, I tell them that straight away. And you can often just see the stress come off them because they go, oh, thank goodness I don't have to rehash this again. And then the other thing I say, which I'd like to get your views on, is at the top of a conference, meeting with a client, I'll often say to them, you're in control of the process today. We act on your instructions. We're here to give you advice, but at the end of the day, you're in control of this process today. Is that helpful to do for someone who's had PTSD?
Yes and no. Yes, if they're in a position to be able to take it, but often helpless, hopeless, feel adrift and want direction from you as their barrister or representative.
So it's important they feel supported and guided through the process.
Exactly.
It's interesting, because I sound like a broken record at the speech I give to people about the process, but it's about understanding the process and what they're in for and why. And on that point, Charlotte, what's your view? Sometimes people approach me as a mediator and say it's too triggering to have a plaintiff in the room. And I like to encourage the plaintiff to be a participant, but sometimes it might be technical legal arguments and you don't need them there. But my preference is I want people to participate. I want that level of agency. I want it to be as transparent a process as it can, because messages are lost in translation. What's your view on that?
I always try and take my lead from the plaintiff themselves, but I always do give the advice of, well, if you're in the room, you know what's happened and you can understand the process a little better. But then I always try and counterbalance that with, if I know a particular person in the room on the other side might not be helpful for it, or they're going to inflame tensions or make it a bit inflammatory, I might just give them the advice that it may be triggering. So I often do like to give them the decision. I do, though, like having generally plaintiffs in the room to hear what's going on, because oftentimes at a settlement conference, they're not being asked questions or cross-examined. And unfortunately, at some point in time, depending on the claim, I may have to say, well, at trial, you will get cross-examined. And it will not be a very fun process for you.
That's the conversation that I have. I go, well, listen, I guess my test is it helpful to the process? Because the last thing you want to do as a mediator is have, light a match, and make it inflammatory. That's what you don't want to do. So I'm guided a bit by my intuition and judgment and reading the room and the personalities. But definitely I say to plaintiffs, well, if you find this stressful, imagine being cross-examined for a day and a half, which is par for the course. All right, let's talk a bit then about, I think there's a misunderstanding sometimes about what a trauma-informed process is. You talked about the importance of empathy and not drilling down, but you obviously need to also test evidence. And how do we get that right within the system?
That's a really loaded question. I think it sort of starts at a molecular level with the client. So what can be really, really challenging with someone with PTSD, and you may have touched on it already, but usually their stories aren't linear and the versions of events they give aren't always exactly the same. So that can be a confronting thing where, unfortunately, the other side want to highlight inconsistencies. And so it's having to navigate that with them. But then also the way I try and frame it is, this is how a judge has to view your matter. There might be issues A, B, and C, and this is how a judge might interpret it. But then still emphasising that obviously I'm still on their team, we're trying to get to the same objective. But it can be really difficult because you sometimes have to give really harsh and blunt advice to people who are psychologically affected. It might even go so far as the claim may not be winnable anymore.
Yeah.
And that's really hard to deliver to someone who may have been through the claim process. And sometimes I'm coming at the 11th hour saying that as someone they don't know, they haven't told their story to. But the nature of the adversarial process is that there's going to be a winner and a loser. And so that's sort of where it all ends up.
Agreed. Your comments on that, Dr. Lovell?
I'm usually cross-examined on what I've written, and if there are any discrepancies between my report and the other psychiatrist who's involved, I will explain my logic and reasoning as to why I've made the opinion that I have. Obviously, the claimant's often there, and I tend not to go into too great a detail in regard to the trauma, but just simply justify my opinion.
Yeah, I hear you. I mean, I guess it comes down to the fine line between trauma-informed process shouldn't be conflated with everyone has to be believed. There's an obligation to test evidence. That's how the court processes work. And obviously, one of the topics you covered off last time is this perception of justice, which is understandable. And often the real job is educating people about what the legal process can and can't achieve for you, because it has its limitations in terms of what is proverbial justice, particularly in compensation, where it's about.
And it can be a long process for them as well too, with PTSD, in and out of affidavits or wherever their claim is up to as well too.
Absolutely.
Yeah, and reliving it.
I think that's really useful in terms of just touching very briefly on how to approach it practically and the trauma-informed process. We spoke last time about resilience and how it is that some people, you spoke about some personality factors from memory. I was obsessional.
Yeah,
There's
you
no
were,
surprise
you
there.
were.
No surprise there. We spoke about adverse events in childhood, particularly sexual abuse, some startling numbers there, and how that can predispose. I want to bring in Charlotte here because, we know these factors loom large and vulnerability is such an important thing, but what does the law say about causation in this context?
So causation can be really tricky, but when you're talking about predispositions and vulnerabilities, that sort of invokes the eggshell skull rule. A defendant is liable for the harm even if the skull is thin. Now, that can incorporate pre-existing vulnerabilities, so life factors that may have happened before. Now, that's a separate and distinct issue to a pre-existing injury.
Yeah.
Now, that can then obviously muddy the waters as to causation, but those pre-existing vulnerabilities can be interesting because some people try and use that as a factor to try and suggest that they're not liable for the harm.
Yeah, so sort of you've got to skate this view between you take your plaintiff as you find them, which is the eggshell sales rule, and people come in all sorts with vulnerabilities, but you might be able to just get some traction as a defendant on the argument that having regard to, say, the type of stress or anything, or that there might have been some vulnerability that may have potentially surfaced in the future. How does the law look at that?
So in terms of causation, the sort of bare minimum standard that you arrive at is the plaintiff has to prove every element of the cause of action. So it's duty, breach, causation. Causation is one part. Under the Civil Liability Act, it's that the negligence was a necessary condition for the occurrence of the harm. Now, if you can get to what that means, we'll all be out of a job. But essentially, the negligence has to cause the harm. And then what can be relevant is whether there's a pre-existing injury that's been aggravated or exacerbated. So then the defendant might not be liable for the whole lot, but the aggravation and the exacerbation. But then there's factors of, is there another separate injury that's causing the harm?
Yep.
And then the onus sort of shifts a bit to the defendant to suggest, well, this other injury is causing the harm, not what you're trying to be compensated for. So it can get really tricky. And particularly with psychiatric injuries, trying to disentangle all of that is additionally difficult. And then even more so in cases of childhood sexual abuse, sometimes the opinion might be this person at this age might not have ever been diagnosed with this injury, but we think at this age, in any event, they may have had X, Y, and Z disorder, which then obviously makes it eternally more difficult to try and disentangle.
I mean, I think it's really difficult when there are two separate insurers involved and there's like 12 months between the accidents. And the history is I had a terrible motorcycle accident, but I was just getting back on my feet. And then I had a rear end collision, bang. And then all these trauma symptoms come. Then the insurers are at each other's throat trying to work out, is it due to the first or the second accident? And trying to untangle it is like a ball of wool. And then you've got to weave all the other issues that are happening in their life, like their daughter was suffering from leukemia or the death of their dog and the effects that those things have had. And it is really very difficult.
And one thing that's difficult, particularly when you're advising a plaintiff, is that you're having to tell them about all these other factors in their life. And usually the first words out of their mouth are, that's not relevant to my claim. It has nothing to do with the accident or the incident I was involved in. But you often have to say to clients, well, a judge looks at your entire life to make sure that the compensation you're receiving is appropriate. So sometimes those other factors do become relevant, particularly if the defendant's agitating it and has adduced evidence about it. So that's also a really tricky conversation to have, that you've already been put in this situation, but then all these other factors have to be examined as well. Your whole life's under the microscope.
Yeah. And in sexual abuse cases that I've mediated, the sadness is the events subject to coming up to proof, of course, but also just the adverse life experiences that people have had in care, etc. So disentangling that can be very difficult, of course.
Then we've got the whole issue of false memories.
Yeah.
Which really confounds the whole thing. People are very suggestible, and if they get chest pain, a bad therapist might say, "You've got that chest pain because that's when your stepfather sat on your chest and forced you to have sexual relations with him." And they come to believe that after a period of time. It's like rewriting history. And it's very difficult, particularly in borderline patients, to work out what's real and what isn't.
Mm. And do you often get asked the hypothetical question then about was there vulnerability that may have surfaced and how it may have surfaced? And can you have a go at answering that? It's very hypothetical and very speculative.
What I'm often asked is, would this have happened but for the event?
Yes.
And all I can do is look at the earlier history and say, look, hey, yeah, they've got an episode of major depression at the moment. They've had 3 earlier episodes. The chances of them having further episodes of depression is 90%. And this is a trigger, but it may have happened in any event.
Yeah.
In terms of the courtroom atmosphere, it's adversarial. And unfortunately, once a plaintiff is in the witness box and they're getting cross-examined, it is going to be everything you sort of talked about earlier. That's not the trauma-informed approach. So how would you go about assisting a plaintiff who has to give evidence and get cross-examined? How would you prepare them for that?
I think you do a rehearsal.
Would you go to the court as well and show them the room? And
yeah, you've got to desensitise them for the process so that their anxiety levels are lessened. And maybe you're going to have to run through the sort of questions that you anticipate that they're going to be asked and stop being their barrister and be the bad guy. Do a few role plays so that they're a little tougher and a little more resilient to deal with what they're going to cop when they're being cross-examined.
Very interesting. On the question of pre-existing conditions, can you remind us, Doctor, about personality factors? I recall you talking about some adverse. There was a third, was there not? A category of
previous trauma.
Previous trauma, yeah.
Okay, they've been in an earlier road traffic accident, or they've had a sexual assault previously. Socioeconomic class, education, IQ, capacity to process information. And I mean, I think too, if they've got an anxiety disorder, that does make them more prone to PTSD. They will be more vigilant. They will have more obsessional thoughts because obsessional thoughts are part of an anxiety disorder. And as we said earlier, it used to be in the anxiety chapter, now it's in the trauma chapter. So they've got to have some tools to try and manage their anxiety and deal with the re-traumatisation which court inevitably involves.
Can you tell us a bit, Dr. Lovell, about complex PTSD?
I mean, essentially it refers to repeated early trauma that might involve childhood sexual abuse. It could involve captivity. Usually the sufferer is a child, and what happens is that relationships are affected, there's affective dysregulation, there's a lot of negative self-image, self-blame. There is an association, a very strong association between chronic pain syndromes and complex PTSD.
Right.
Similarly, there's a strong association with irritable bowel syndrome and chronic fatigue. People who have been abused at an early age don't have the psychological wherewithal to process it, and they tend to somatise. And these somatic behaviours follow them for the rest of their life. They're in a road traffic accident. There's no underlying objective pathology. They're traumatised because they're vulnerable, and their presentation is often with chronic neck pain or atypical syndromes of pain, and they fall into the clutches of pain management specialists and have all sorts of injections. And
we've seen all that.
Sadly, there's no such thing as a free lunch when you actually get spinal cord stimulators implanted and the actual pathology isn't there. You almost inevitably end up with iatrogenic pathology instead of going back to the fact that, hey, it's a somatic representation of early trauma.
Mm.
Can I ask a question about where capacity might come in with complex PTSD? And have you seen cases where someone has complex PTSD so severely that it actually might inhibit their capacity to give instructions? Or are there certain disorders that you see that are common with people not having capacity to give instructions?
A lot, if the trauma's been severe, people tend to dissociate and they lose time and they're not taking in what you're saying. And particularly in a stressful situation like in court, they may not actually appreciate what's happening. They're somewhere else in their mind. And I think that does interfere with their capacity to give evidence and their capacity to generally accept a settlement.
Mm-hmm.
One of the things I heard you say, which I was interested in last time, about the rule of a thirds, and that a third people, which is quite a high, could actually improve quite significantly. And of course, when it comes across my desk as a mediator, I wonder whether we've lost that third because they're already entrenched in the claim system. Or do you think post litigation, we talked about that as well. Do you think there's a level of optimism, even in people that go through a long claim process, or do you think it's likely that by that stage they're in that 2/3 category that sadly are?
Well, look, I think chronicity predicts chronicity, and really it's all about early intervention, and behavioural patterns, once they're formed, are very difficult to break. The interesting thing that I've seen recently is the delayed onset PTSD. We haven't actually spoken about that. And it's kind of common in veterans, but I often don't believe the syndrome in these cases because they're just about to retire. They reflect back on earlier experiences and wartime experiences, and it's a very subjective diagnosis. But when you see a delayed onset PTSD, it's quite remarkable. I remember the first case I saw was a woman I was treating in an on-site clinic who was a Dutch social worker who was a comfort woman for the Japanese soldiers, and they used a rifle butt to knock out her teeth. She got her life back together and things went reasonably well until her dentures broke and everything flooded back. She made a very significant suicide attempt and she ended up in hospital for about 3 months. And more recently, I've seen an interesting case of a lady who was shot in the head and the hip in Sarajevo as a child. And she managed to get asylum in Australia and things went very well. She became a very senior person in one of the institutions until there was an episode of road rage and it brought everything back. So when it happens, it's very dramatic and it's not like people saying, oh, hey, I'm reaching the end of my time. I did 5 years in the service and I'm going to go back and I'm going to look for everything when somebody yelled at me and I'm going to go and see my advocate and try and get a claim going so that I can get a gold card to cover me in retirement.
So those stories make sense because you can see clinically how it pieces together. But that's really interesting, delayed, because how do you marry that up with the category 1 stressor and the delay? It's fascinating, isn't it?
Yeah, it is. I mean, it's never been processed earlier on. And then we get the trigger. In this case, it's someone in their mouth or someone shaking their fist and a threat that they're going to be killed. And you can usually go back and get a history of them being somewhere else when this trauma was happening. And I mean, how else do you cope with it?
That's right.
You can't. You've just got to be in another place.
Doctor, you mentioned before about early treatment being important in terms of the outcome. When you say early, do you mean in the months, years? Like, when is it sort of past the point generally of no return in terms of, not no return, but it's getting into that 1/3 category or 2/3 category that may not resolve?
ASAP.
Okay.
1 or 2 days. I mean, we're not talking about delving into the trauma. We're talking about, are you all right? Can I make you a cup of tea? Who have you got to talk to about this? Can we help in the workplace? Would you like to see someone from EAP? Look, you've had a truck accident. There's an organisation around that helps people who are truck drivers who have had people drive into their truck and they've killed somebody. Can we put you in touch with them?
So something as simple as even just offering a hot drink and EAP can get you on the path to some sort of better clinical outcome. Okay, that's really interesting, because you sort of think with PTSD and serious psychological issues that you sort of need really intense treatment straight away. You're sort of thinking of, the old school, treatment they used to give. But that's fascinating, because you don't sort of think about that immediate response and how it might change.
Just being kind to people. After they've been hit by a car and the driver's left the scene, I mean, their view of the world changes and they think, God, the world's a horrible place. Nobody cares about me. And then all of a sudden, bang, you're making some practical suggestions. You're trying to help. And there you've got your relationship, and subsequently you can work on the claim if they choose to continue to see you.
That was borne out by the numbers you gave in the last episode around what happened to September 11 victims. I thought that was remarkable, the low incidence. And that's a feature of the early acknowledgement, the acceptance, the everyone rallying around, the community aspect. It's fascinating, but because it's such a, category A stressor, isn't it?
It's a shocker.
It's a total shocker. So that early intervention piece and that acceptance and that empathetic ear, that kindness, and that's a great message for employers, isn't it? About
for the employers to check in with the people as well too, because how many people are at home and no one's calling them after an event in the workplace as well.
My workplace hasn't had any contact.
We
you
hear
hear
that
that
all
a
the
bit.
time.
That's a very common
Since
complaint.
I lost my hand in the machine.
Yeah,
No one
If they
even rang
really
up.
cared, they would have sent somebody around to see how I was
that's
doing.
right. That's very common.
And the isolation makes it worse.
And that's the common
Yeah.
trigger often then to see a lawyer or to it's very personal factors or refusal of surgery or a treatment or something like that, or something very personal. That was a great conversation. Sorry we didn't cover off on the Lions' success last year, but we can come to that.
That's okay. We don't want to jinx it for this year.
Indeed, we don't. So thank you, Dr. Lovell. Thank you, Vanessa. Thank you,
Thank
Charlotte.
you.
Thank you.
That was a great conversation about some practical takeaways, and look forward to further work and collaboration with MLCOA.
Thank you. Thanks, everyone.
Cheers.
Thanks.